आधे बाउल दही में 4 चम्मच MDH चटनी पुदीना मसाला डाला, स्टर करो, पुदीना चटनी तैयार। MDH चटनी पुदीना मसाला।
Replaying that very important, if I may say, historic interview with the former Chief Justice of India. And I want to say one thing before I play this for you. Ladies and gentlemen, I want you to watch the entire interview and follow every word and judge for yourself. You judge, I won't. Whether you find the former Chief Justice of India, B.R. Gavai, convincing at all, underline at all, about his own Aravali verdict. I'm going to run that poll live. You decide. Here it is. Ladies and gentlemen, it is my attempt always to go to the nub of the issue. Joining us is Justice B.R. Gavai, former Chief Justice of India and the author of this judgment on the Aravalis, which is being debated all over the country. Justice Gavai, I hope you will go through my questions and give me appropriate replies, because fundamentally, and I would like to begin by saying this, Justice Gavai, that I have a fundamental disagreement with your judgment, which as a citizen of India, I'm entitled to have. The Aravalis stood for 2 billion years. The judgment that has redefined them was delivered 3 days before your retirement. What was the hurry, Justice Gavai? The judgment was delivered on 20th November and you retired on 23rd November. What was the tearing hurry?
See, I have been monitoring this issue for more than 3 years. If you go through the judgment, we had raised, firstly, see, judges are not supposed to justify their judgment, but since this is an important issue and there's a misconception about the judgment, I agreed to speak to you. If you go through the judgment entirely, the difficulty is that the persons speak about the judgment without even reading them in the entirety. So if you go through the entire judgment, I had given the entire narration as to how the matter arose. There was some issue with regard to the difference adopted by the various states with regard to definition of Aravali hills and Aravali ranges. So in order to settle those matters, we heard the matter on number of occasions. Various issues were framed, and after hearing the matter, once you hear the matter at length, if you don't decide the judgment, it's like
Justice Gavai, may I ask you, how can you pass that comment on me on my program, that I have made my judgments on the issue without having gone through the judgment? I would politely, completely disagree with this presumption of yours and remind you that I have seen your judgment in entirety. In fact, no, I don't think you can pass a judgment like that, pass a comment like that on my observations, sir. I take offense to that. Having said that.
What I've seen on your program is that it's not necessary that always the court has to accept the submissions are made by one behalf. Maybe the learned amicus is a friend of a court. The court has to consider all the aspects, and after considering the aspect, the court comes to an opinion. So it is not as if that we have to accept the arguments.
No, but the amicus curiae, respected Mr. Justice Gavai, was going by the FSI criteria, but it said that the FSI criteria better preserve the ecological integrity of the Aravalis. Mike, with due respect to you, Justice Gavai, the FSI is comprised of India's topmost and most respected experts on matters of ecology and environment. Does that not matter to you? Are the experts less aware than the government? Or for that matter, less aware than the judiciary?
Mr. Arnab, the FSI was also a part of the larger committee which was appointed by the court. The committee consisted of various experts from various fields, including the representative of the FSI. And the report which was submitted was not only by the government, it was a report of the experts.
Sir, I am quoting from your judgment, para 27. The FSI had clearly defined the Aravalis in 2010 as, quote, under slope over 3 degrees, foothill buffer equal 100 meters, interhill distance or valley width equal 500 meter, and for the area enclosed by the above defined hills from all sides. What was the need to revisit this definition in the first place?
There was no question of...
Why did you have to
Therefore,
revisit this definition in the first place?
So therefore, I made a submission that the comments are made without reading the judgment. If you go through the earlier parts of the judgment, the necessity was felt because all the 4 different states applied different yardstick insofar as the definition of Aravalli Hills and definition of Aravalli ranges are concerned.
But that can't be a reason, sir. The fact that the old definition...
Please,
sir. The fact is the old definition... The fact is the old definition recognizes slope, buffer, valley, enclosure and continuity, the very elements that make a mountain range a living ecological system, not a collection of isolated bumps. And yet the court walked away from it. Why?
The court has not walked through it. On the contrary, if you read the operative paragraphs as well as the earlier paragraphs, we have specifically said that on a Saranda pattern, the MSAP has to be prepared wherein the mining which it will provide, which are the areas where the mining will be prohibited and where the sustainable mining would be permitted.
Sir, I would request you, Justice Gavai, there is a precautionary principle in law. The precautionary principle applies in this case, doesn't it? The precautionary principle in environmental cases means taking preventive action to protect the environment from serious or irreversible harm, even when there is no scientific evidence which is not fully conclusive. This means, as per precedent of the law, the onus is on precaution and safety. Why didn't you apply? I would like to ask you, you have been the Chief Justice of India. The nation wants to know from you, you've been Chief Justice of India in this case, why did you not apply the precautionary principle in this case? There have been innumerable precedents of precautionary principles being applied by the honorable courts on matters of environment. I don't find those quoted in your judgment. May I ask you why?
If you read the operative part, it is very much clear that unless the MSCP is finalized by the IFTRI and finalized by the MOEF, no further mining licenses would be granted.
Justice Gavai, Vellore Citizens Welfare Forum versus Union of India 1996. The Supreme Court declared the precautionary principle a legally enforceable principle crucial for sustainable development and shifted the onus of proof onto polluters. MC Mehta versus Union of India, Taj Trapezium case 1986. The Supreme Court used the precautionary principle to stop industries from burning coal near the Taj Mahal, recognizing harm from pollution. I am not an advocate, but I'm asking the former Chief Justice of India, a matter of principle, why did Justice Gavai not apply? Why did the 3-judge bench not apply the precautionary principle in this case?
If you kindly go through the operative part, clause 4 and 5 make it very much clear that unless the MSAP is finalized by IFTRI and MOEF, no further mining leases will be granted in all 4 states in the Aravalli Hills.
Sir, the precautionary principle means that in matters that are likely to affect the environment, it is not required to prove that the activity will cause harm, but that the activity is prohibited unless it can be established that it is benign. No one is suggesting here that deforesting the Aravallis will... Sir?
What does the prohibition on the new mining licenses amount to?
Okay, sir, then let me ask you the AP Pollution Control Board versus MV Naidu case 1990 to 2000. Landmark Indian Supreme Court judgment that reinforced the precautionary principle, established the right to clean water as a part of the right to life, Article 21, and placed the burden of proof on polluters. All these cases were there for you to look at, sir.
We have looked at the cases, and this is T.N. Godavaram and N.C. Mehta are the continuing mandamus proceedings. They are not as if we have closed the matters.
What do you mean?
The
it's not as
continuing.
Sir, I'm asking. So you're saying the matter is not closed?
The matter is not closed. We have directed the MSCP to get the report. The MSCP report will come to the Supreme Court. Supreme Court will find out wherein the mining activities are to be permitted and where they are to be prohibited. It is not as if that the matter is closed.
Sir, but you've not looked at other cases which were in the public domain. There is a May report by the government. It's titled Detailed Action Plan Aravalli Landscape Restoration, in brackets Aravalli Green Wall. The irony is this report was published by the Ministry of Environment and Forests. It's not even an old report. It was published in May 25, just 8 months before the Supreme Court redefined the Aravallis. It involved the Forest Survey of India, state forest departments of Delhi, Gujarat, Haryana, Rajasthan, along with German Cooperation for International Cooperation. Now, this report was in the public domain and the nation wants to know from you, Justice Gavai, justify, as the former Chief Justice of India, would you see it the other way, that this report had very much established the threat to the Aravallis? 8 months before your judgment, your new definition allows for leeway by the mining players to exploit an already depleting resource.
Mr. Arnab Goswami, it is firstly not the definition provided by the court. It is a report of the committee of the experts. The court found that the report was liable to be accepted subject to the further requirement regarding, I am again repeating we are again going to the...
So you don't completely agree with the government's version, which the government says we are only going by what the Supreme Court says. You are saying you're only going by what the government told.
We are going by what the report of the experts, of which the FSO was also a party. We only accepted that, and in addition to acceptance, we imposed certain stringent conditions which would protect the mining activities. Unless the MSCP is finalized, no further mining will be permitted.
Sir, you've seen Sir, you've seen the report.
If you kindly go through paragraph 4 and paragraph 5 of the operative order, it is more than clear.
Sir, you have seen the affidavit out here, sir, of the government which was filed in this case, because I have gone through it in detail. It's 2000. You say I have not seen the reports, but I have read every word of the 2,334-page additional affidavit filed by the Ministry of Environment. Sir, I am very detailed in my work. Sir, the fact of the matter is the government is trying to institutionalize mining as a core objective, not as an exception, by formally designing a framework whose purpose is to enable exploitation, mining inside the Aravallis.
No, but then we have not accepted that. We have specifically stated that unless and until MSAP, the management of sustainable development plan, is finalized, no further mining.
Sir, may I ask you a question, sir? You also said, sir, now that there is considerable public outrage on this matter, and by informed people, not uninformed people, do you believe that if necessary, this matter should be looked at again, reviewed, discussed?
I have always stated that the law has to be static, law has to be developing, law has to be organic.
Yes.
We have, on various occasions, wherever we have found that earlier orders are not correct, the courts have always corrected them.
So,
therefore, I was not inclined to speak to you, because the matter may come in review, and normally the author of the judgment should not speak about the judgment. But since you insisted that this is an important issue pertaining to environment,
yes.
So if the subsequent benches find that something more to be done, it is always permissible.
So
the TNF Godavarnam is a continuous mandamus process.
So it can come up for review. I mean, you're not. I mean, your view is given. I'm sure you've kept track of the public discussion on this matter, sir, over the last few days, and the amount of attention it has got.
If the court subsequently finds that something more needs to be done, something needs to be corrected, the courts can always do it.
And the government should be open to review as well, given all the expert opinion, others, it can be put through review again, this decision, this definition, in public interest?
So I can't.